Hello students, this is Professor Del Russo and I can't be in class today, February 21st, 2011. I apologize, but I'm going to present to you substantially the same lecture I would have given had I been in class this evening. And you need to listen to it all. It's a little bit longer than typical, but less than our class time. It's from last February, and you'll see my introduction mentions that it is from last February, but it has the same content that we would have talked about tonight in class. So good luck, and I'll see you next week. Okay, today is February 15, 2010. This is Children in Justice, spring semester. We're in our fourth class, I believe. And last week we ended with plea bargaining. And what I was trying to do was kind of follow loosely the process from investigation, although we will talk about investigation later in the semester, but from investigation and arrest through the court system. We talked with great specificity last week about the structure of the American court system, and specifically New Jersey, and the role of the trial courts and the appellate courts, and the similar structure within the federal system, the federal district trial courts, as well as the federal courts of appeals throughout the country, and the circuits that they exist in. I think I may have mentioned the district court trial out in San Francisco about the constitutionality of the California state constitution's requirement that marriage be only available to men and women, not to same-sex partners. And I think I also mentioned a federal district court trial in the District of New Jersey that was being prosecuted last week as an example of a trial court process in the federal system, and that was the trial of the deputy mayor of Jersey City, a 74-year-old grandmother, so the media wrote in the summary of her conviction, which occurred between last week and this week. Former burlesque queen, apparently, for what it's worth. But nevertheless, she was tried in the federal district court at the trial level. And then if there were any mistakes of law or any erroneous applications of the rules of evidence, any mistakes about the stuff that the jury got to hear in that case, at the trial level, she can highlight those for the appellate courts. The appellate tribunal for our area is the Third Circuit Court of Appeals. Covers New Jersey, Delaware, New York. I think we looked it up last week. But in any event, that's where she's going, I'm sure, to the Third Circuit Court of Appeals. So we took a look at the structure of the courts, and then we looked at the first thing that really happens, the first event that occurs when someone is charged with a crime. When attorneys get represented, when attorneys represent people accused of crimes throughout this country, the first order of business, the first thing that the defendant, and more often the family, wants the attorney to do is what? Especially if they're in the county jail. What does the family want to happen? The first thing you do when you pay the lawyer, what do you want her to do for your brother, cousin, aunt, uncle, whomever? Get him out. Get her out of jail. What do we need to do? And the way to do that is to request a reasonable bail. So we talked at length about what it means in American jurisprudence to have a reasonable bail set. What are the factors that courts look at in setting reasonable bails? And what kinds of conditions, what kinds of things can you require of the accused if they are going to be given liberty, if they're going to be allowed to be at liberty before there's ever an adjudication, before there's ever an evaluation of guilt or innocence. So we looked at all that. And once bail is set, and a person makes bail and they're at liberty, then the next step is a trial. And in between the finalization of the arrest and the bail, some people don't make bail and they sit in the local jail until there's a trial, even though they are presumed innocent. But between the initial stages of a criminal case, which includes the arrest, a first appearance, or arraignment, you may hear the term arraignment from time to time. That's simply an initial appearance where the court kind of gets to meet and greet with the accused. What's your name? Who's your lawyer? How do you plead? This is where you got to be. Write down my courtroom chambers number so you know where to go in the future. It's kind of the early stages of the prosecution where what you might call housekeeping is done. And the court wants to get a formal plea, and that's really the foundation of an arraignment. That's really what arraignments are about, to get the defendant's formal plea, guilty or not guilty. 99.9%, if not 100% of criminal defendants enter a plea of not guilty. I mean, you could be, on videotape confessing. There could be a videotape of the crime and, 44 bishops were walking by and saw it. You're still going to enter a plea of not guilty because it's really a formality. The process of resolving the case will happen later. That request for a plea of guilty or not guilty is really a bit misleading. The purpose is to make sure that you got a lawyer, make sure we have your address, make sure we have your right social security number, make sure you understand that you need to come to court periodically. It's, as I said a moment ago, a kind of meet and greet. A little bit more than that, get to know each other kind of process. The arraignment. The arraignment. Between the arraignment and the early stages of the criminal justice prosecution and the actual trial, there's a wide gap of time. In many cases, in many places, it takes about 2 years to resolve a case, perhaps longer. That's certainly about right in most of New Jersey, if not all of New Jersey, and in most states around the country. The federal system moves a little more quickly. The juvenile system is quite different, and we'll talk about that in a moment. But between the arraignment and the trial, or the resolution of the case, there's lots of stops along the way. And they are called calendar calls, status conferences, trial calls. Around the country they have different names. But when the person who's charged, whether it be the person in the hypothetical in your book, the Reddings case, when Mr. Redding was arraigned, and between the time he's arraigned and ultimately the subject of a trial, he will appear in court dozens of times. And perhaps the first time might be about 6 to 8 weeks later. And then the lawyers will meet with the judge and attempt to talk out the case and see what its strengths are, what its weaknesses are, how long the trial might take, if there are any unusual issues in the trial. Are there going to be any motions filed? And I'll tell you what they are in a second. But you have these, what I describe as calendar calls, trial calls, status conferences, that are designed to evaluate the case and for the parties to discuss it with an eye towards resolving it, whether it be a plea bargain, which we discussed at the end of last class, or ultimately a trial, where a jury will decide guilt or innocence. And by the time the first appearance happens, the first status conference rather, and the defense lawyer meets with the judge and the prosecutor about Mr. Redding. What's Redding's name in that hypothetical? Does someone remember what the Redding's name is? Mr. Redding? I think it's Joel. But Roger Redding. Roger Redding, a little alliteration there. Between Roger Redding's first time with his lawyer in court for the arraignment and then the first status conference, he will have met with his lawyer. They'll talk about the case, and they'll have a sense of, what their position is or ought to be. Then they meet with the prosecutor and the judge at that first status conference, and they talk about the pros and cons, and as I described a moment ago. Other issues that might come up are not only motions or important aspects of this particular prosecution, but also whether discovery is complete. Discovery is an important concept in both the civil and criminal system, within the legal system. And discovery simply is the exchange of documents and materials by both parties to an action. So in the case of a criminal prosecution, the prosecutor will turn over all of the police reports, any laboratory reports, any medical reports, any documentation that supports the state's case or the government's case. So if Roger Redding was charged with aggravated sexual assault upon his daughter, and I think he was, something like that, the prosecutor's case might consist of the original police report, maybe a statement from mom, if the little girl told mom what happened, which led to the authorities being involved. Maybe there was a initial response from the Division of Youth and Family Services. Maybe that worker was interviewed by the prosecutor's office. There may have been a medical evaluation of the child at a regional diagnostic center or at a local clinic or at the emergency room or by the family's pediatrician. Kids get medically evaluated at a variety of places, many of which aren't optimum for the kid, but it's what happens. If the prosecutor is in possession of those medical reports or ought to be in possession of those reports, they need to be shared with the defense. If the suspect, if Roger Redding made any statements, or we video recorded an interview with Roger Redding, we have to give a copy of that video recording over to the defense. Anything we're going to use, anything the government is going to use to prosecute Roger Redding, and anything we may know about or be aware of that demonstrates his innocence, or the test is far more liberal than that, or forgiving for the defendant or the accused within the New Jersey courts, anything that might be favorable to the defense needs to be turned over. So the prosecution shows all of their cards to the defense way early in the case. In fact, even before meaningful dialogue happens. Not only shows the cards, they have to copy, package, and deliver the cards to the defense. It is so critical that if the prosecutor attempts to bring up some new piece of evidence on the eve of trial or during the trial, it is highly likely that evidence will be barred, despite how damning or persuasive it may be, because you need to give the defense all of the discovery. Okay. Similarly, the defendant, if she or he is going to rely, in the case of Roger Redding, if he's going to rely on something, he has to share that with the prosecution. If, however, let's say Roger Redding wanted to argue that he was mentally incapacitated when he committed the offense, that he has some diminished capacity defense. In other words, I did it, but I didn't know what I was doing at the time. Like I was insane or had some mental defect that prevented me from understanding what I was doing. That defense, not that popular with incest cases or sexual assault. It happens in robberies and more so in shootings and homicides and things like that. But nevertheless, if Roger Redding was arguing that he had some sort of diminished capacity, some kind of mental illness at the time that the crime happened, therefore he should not be held responsible, and he got a doctor to evaluate him that agreed with that or put forth that proposition, then he has to share that with the prosecutor. So discovery is mutual, unless, let's say Roger Redden went to a doctor, got evaluated, and that doctor wrote a report and said, Mr. Defense Lawyer, Roger Redden was not suffering from diminished capacity. He has no mental illness or defect and knew exactly what he was doing when he committed the crime. The defense does not have to share that with the prosecution. They can just shred it or keep it in their file for whatever reasons for the future. The defense does not have to share and is not compelled to share inculpatory evidence with the prosecution. Inculpatory meaning evidence that demonstrates that you're guilty or did the crime or did something wrong. Inculpatory. What amendment do you think really compels such a rule? What amendment do you think would be the best support for a rule that says if the defense gets their client evaluated and the report says the guy knew exactly what he was doing, that he doesn't have a mental disease or defect, that the defendant does not have to give that to the government to use against him? What amendment do you think that arises out of? The fifth. Were you going to say the fifth? Very good, but what makes you say that?
Because it's giving the prosecutor the opportunity to use that information against him.
It would give the prosecutor the opportunity to use that information against him. And what is the sacred rule within the Fifth Amendment that says the government can never do what? Oh, God.
To have him
Be a
witness against himself.
And that is the constitutional predicate for that discovery rule. Again, discovery is simply the exchange of information between adverse parties in a legal proceeding. Now, the civil system works quite differently in some aspects. Some aspects it's similar, but in some aspects it's different. A lot of their discovery is created through depositions, these kind of formal questions and answer sessions that can go on and on for a long time before there's ever a trial of the facts. But nevertheless, the same basic principles apply. You know, if I'm suing Toyota Motor Company because I'm alleging they have a defective accelerator, and the Toyota Motor Company says, you know, you were driving a 1986 Celica, that's not an issue. It was not designed effectively, and the accident had nothing to do with our negligence. Well, Toyota and the plaintiff, Del Russo, will exchange discovery. They'll have to give us whatever documents they're going to rely on, and I, as the plaintiff, would have to give Toyota Motor Company whatever documents I was going to rely on as well. So that's the exchange of information, and that's what happens early in the case. And Roger Redden, for example, is charged with aggravated assault. He goes to that arraignment. He goes to that status conference. One of the things the judge wants to know, in addition to what kind of unusual issues might there be, if we try this, how many days will it take? You know, what kind of plea offer could you make, Mr. Prosecutor or Madam Prosecutor? What kind of plea offer do you think? What kind of plea offer do you think Roger Redden might take, Ms. Defense Lawyer? They talk about that. And it's not only the Roger Redden case that's on any given trial day. Typically, at least in my experience in Passaic County, and it's very similar throughout the state, in your urban counties, you know, Salem County, Gloucester, Cumberland, Hunterdon, Sussex, a bit different. But they still have, in Sussex, 8 or 10 cases on a Monday. Mondays when these cases are discussed. That's the calendar call day. In most states, by the way. Passaic County, on any Monday, there's 16 to 18 of these cases on. 16 to 18 Roger and Sarah Reddings sitting in the courtroom, all whose case is on the docket. Each one of them accused of something different, from, you know, possession of methamphetamine to armed robbery to murder to domestic violence to burglary to criminal mischief to sexual abuse of a child. All of these defendants, all 16 to 18 of them, arrive every Monday morning. Only one can go to trial in any given week. And it may even take 2 weeks, maybe 3 weeks sometimes, to try the case. So the purpose of these status conferences or calendar calls is to try to resolve them. I mean, that is really what the criminal justice system is all about in America. Not trying cases, not presenting the facts before an impartial jury, but resolving those cases, reaching a consensus or a compromise or a plea agreement or a plea bargain before there's a trial. Every state in America has plea bargaining. Every county in America has plea bargaining. One state attempted to get rid of plea bargaining, to eliminate plea bargaining. And they did for a little while. Can someone guess what state in America abolished plea bargaining? Go ahead. Texas? No. No. Well, the problem with Texas and Florida is those are high crime states, high prosecution states. Texas and Florida share something in common. They're the capital crime capitals of the world, so to speak. They are the death penalty capitals of America. More people are executed in those states, and Oklahoma and a few others. But no, it's kind of the opposite of those states. Because if plea bargaining is a response to a process that is overwhelmed by the sheer amount of cases, and we say plea bargaining is a necessity, because you can't have 18 cases every week. So it would have to be a state that's less populous. Alaska. It was Alaska. Alaska abolished plea bargaining for a short time, but it didn't really work out. Interestingly, and inconsistent with what I just said, they purported to abolish plea bargaining in Bronx County, New York, in perhaps the 70s or 80s. I forget when, but that was snake oil. They interpreted plea bargaining as meaning placing a limit on the amount of years someone was exposed to. So if you were guilty in New Jersey, let's say, of a second-degree offense, and the maximum jail time on a second degree is 10 years, and we said, oh, if you plead guilty with second degree, you only can get a maximum of 7 years, in the Bronx, they'd say that's a plea bargain. But if you were charged with a first, second, and third degree offense, and in the Bronx you dismissed the first degree count and only kept the second and third degree count, they would say, well, that's not plea bargaining. So they only saw plea bargaining as a limit on the amount of years, not on the dismissal of counts, which is disingenuous at best. I mean, that sham didn't last very long either. Every state has plea bargaining. It's a necessity. It's important for all the reasons we talked about last week. You know, economy, finality, and certainty. And it is mutually beneficial. Every Monday when those 16 cases are on the list, and there's 16 Roger Reddings and 16 Sarah Reddings sitting in the courtroom, any one of them could go to trial. Any one of them. One will. And then 17 others will be churned and put on the calendar for 5 or 6 weeks from now. But it doesn't matter, because the following Monday there's 18 different cases. And only one of those will go to trial, and the other 17. So you have calendar call roulette every Monday. The problem is one of those cases might be you. Imagine if this classroom was the calendar on a Monday. This is about what the courtroom looks like. Maybe there's 17 or 18 of you here today, I don't know, but this is what it looks like. One of you will go to trial. One of you will have to put on your blue suit and your red tie and your gray slacks and have to sit there and stare at 14 people that you don't know who will decide whether you go to a prison where you will be caged for most of the day for a period of years. One of you might be that person. Odds are it won't be you, because it's a 1 in 17 or 1 in 18 chance. But eventually, it'll catch up. So when I say it's mutually beneficial, when I say there's finality and certainty, For you, the accused, the 18 people, one of whom may go to trial, there is an emotional consequence, a psychological consequence to having to come to court every week. There is value in getting this thing over, there really is. Especially if you're guilty, right? There is value in putting this behind you and accepting 5 years instead of potentially 20 years, or accepting 8 years instead of potentially 12 years. Certainty, finality. The certainty is, if the case calls for 20 years and the prosecution offers you 7 years, one thing is certain. You will not get 8, 9, 10, 11, 12. You will not get anything more than 7 years. From 8 to 20 isn't on the table anymore. You are certain that the most you will do is 7 years. If you go to trial and a jury decides your fate, well, you could get 20 years. Maybe sentences can run consecutively, that is, successively, one after the other, where maybe you'll get 30 years in prison. There is a big and great unknown if you go to a jury trial and lose. And especially after a jury trial where the sentencing judge presides, she does not decide guilt or innocence, but she listens to the facts and makes rulings about evidence and hears every aspect of the case and also chats it up with the lawyers in those conferences all the way up to the trial for up to 2 years. The judge is fully familiar with all the police reports. Okay? The jury gets a very high-gloss, varnished, distorted look at what happened, but not the judge. So you may be able to present the case in a very favorable light to the jury. But if you get convicted, the judge sees the whole case, and that person's going to sentence you. So you roll the dice, and you go to trial, and you lose. The outcome can be devastating. Whereas if you take the deal and get 7 years, you know what you're in for. And the value applies equally to the family of the victim. Right? Because similarly, the process is long, it's tedious, it's debilitating. That same Monday, the family of the victim, despite the fact that many progressive prosecutors let the victim's family know, listen, I'll let you know when the case is going to go to trial. Don't worry about those notices that come in the mail. It's still disconcerting to get those notices. And if you're the victim's family and you get that subpoena, even though the prosecutor has told you ignore it, don't worry about it, it still puts a little knot in your heart every 6 to 8 weeks, month after month after month. My vacation's coming up, my prom's coming up, my 8th grade dance is coming up. You know, life goes on, but the subpoenas never stop. And one day, the victim and the family and the witnesses have to come to court and talk about the unspeakable. There is value. There is lots of value in finality, in getting this thing over and putting it behind us. Not only for the defendant, as I said a moment ago, but for the victim and the family as well. And there is certainty. There is certainty. Because sure as I'm standing here, pacing back and forth, there can be an acquittal as easily as a conviction, no matter what the quality of the case. And I think I mentioned that last week and gave you a few examples. We know now that maybe he won't get 20 or 30 or 18 or 19 or 16 or 17. He'll get 7. And that's a lock. And that's going to happen. And he's going to have to come in and say, I did it. And we, when I say we, the family of the victim, if there's a family that's supportive, which sadly there isn't always. Very often the prosecutor stands there alone on sentencing day. Sometimes the victim is seated on the other side with the defendant's family. Too often, too many times. But sometimes they sit with the prosecutor. Sometimes they're there, and they get to be heard. And that's valuable. They get to be heard after there's a conviction as well. But again, the trial is an uncertain process. There may not be a conviction, and even if there is a conviction, there is no admission. With a plea, the defendant has to come in and admit it and make a statement, make what we call a factual basis to say they did it. Now, is this far-reaching mea culpa, grand act of remorse? Not even close. But they come in and say, I did it. However vague and shabby that factual basis is, it's still done. They say it, they say they did it, and they come to court on sentence day with a far different posture than if they were convicted after trial. They come in as someone who said they did it. So that the victim and the family can be heard and can approach and speak to the events and to the impact of those events, the molests, and to the acts of that defendant a little bit differently when you know that he admitted it. Or she admitted it, excuse me. So this stuff has value to both sides. Or it wouldn't be enduring, and it wouldn't be widespread. Right? It's lasted for years and years, and it's in every state in America. And those states who tried to get rid of it did so purely for political reasons, not for practical or pragmatic reasons. They were both feeble attempts to win votes or sway public opinion in the direction of whoever came up with those dopey ideas in the Bronx and in Alaska. Plea bargaining is important. So for those 2 years, there's an attempt made to resolve the case through a plea bargain. Sometimes it's resolved, sometimes it's not resolved. Between the arrest and ultimately this series of trial calls, in New Jersey, there's a process known as grand jury presentation. Grand jury. Now, a grand jury, despite the fact that it uses the adjective grand, is neither grand nor really a jury in the sense that they decide guilt or innocence. But they are a body of people, a group of people who decide whether a case should move forward, should be prosecuted. Not every state has the grand jury system. California has something called indictment by information. And there the prosecutor can draw up the charges. But in certain contexts, they have to have a probable cause hearing. So they need to present their evidence anyway in many cases in California. Many states have a grand jury. So when Roger Redden was charged on a criminal complaint, about a month or two later, the prosecutor would take the case and present whatever facts they have to a grand jury. The reason why they call it grand is because it's 23 people. And I think I asked you last week what they call a jury that decides guilt or innocence, right? Does someone know what they call a guilt or innocence jury? What the official term is for the 12 people who decide whether the guy did it or not? Pettit jury. Pettit jury. Just think of Andy Pettit. Baseball player. But anyway, it's a Pettit jury, which kind of means it's related to the word petite. Right? Pettit. It's related to the word petite, meaning smaller, diminutive, little. Grand is grand. So there are 12 jurors who decide guilt or innocence, ultimately 14 are impaneled in most states in a criminal case. And grand jury, 23 people in New Jersey. And those 23 people, they listen to the state's evidence. They listen to the prosecution's evidence. They listen to the police's evidence, to put it a little more succinctly. They listen to the police's evidence, and they decide whether there's enough evidence to go forward. No, you charge somebody on a complaint, and then the grand jury kind of screens the case. It's very useful, the grand jury, because they're allowed to ask questions. Grand jurors are allowed to ask questions, and those questions can be educational for the prosecution. They may give the prosecution insight into how average people think about this case. You know, prosecutors are in their walled offices in their legal world, thinking about things in a particular way, with a particular point of view, they may miss the common sense aspects of a particular case. And the grand jurors can give them an opportunity to see how average people view the evidence. Its primary role, though, is to decide whether to formally charge the accused with an offense. And in New Jersey, that is called an indictment. If a grand jury decides to formally charge someone, the resulting document is known as an indictment. I-N-D-I-C-T-M-E-N-T. Indictment. If there is no indictment, the case is said to have been no-billed. N-O space B-I-L-L-E-D. No-billed. These words are vestiges of another time, of centuries ago, when things were posted and billed and stamped and had seals and wax and different things that were testament to their formality and their importance. So some of these words linger. But we still use them. An indictment if you're charged, and a no-bill if the grand jury decides not to charge. If a grand jury decides to not charge, the prosecutor can present the case to a different panel of 23 people. And the prosecutor can present it to another panel of 23 people. Some have argued that the government can indict a ham sandwich. The assertion being that the process is meaninless. It merely is a rubber stamp to validate the prosecutor's charges. One of my bosses throughout the years, Ron Fava, who was the prosecutor for Passaic County, made the observation, and it's a grand one indeed. Maybe the grand jury can indict a ham sandwich, but who would want to go to trial on a ham sandwich? In other words, you may be able to charge someone, but you still got to go to trial one day. And if it's a lousy case, it's not going to change. It's only going to get worse. When you go to trial in front of a petit jury, and all the rules of evidence apply, and the defendant is represented by counsel, and witnesses are cross-examined and challenged. The reason why they argue or suggest that the grand jury is really a rubber stamp is if the prosecutors show the defendant doesn't get to tell her side of the story. In the Roger Redden case, he doesn't come to court. There's no lawyer for the defendant. There's no evidence on behalf of the defendant presented. The prosecutor presents all of the evidence that the government has that favors them. They don't even have to present evidence that favors the defendant. In New Jersey, the only evidence that you're mandated to present to a grand jury is evidence that directly negates guilt. That means if there was someone else who confessed to the crime, the person against whom you are presenting the case to the grand jury could still be guilty, believe it or not. People confess that aren't guilty sometimes. But you'd still have to present that. Okay? If a child was reportedly digitally penetrated, that is, she was fingered by her uncle, and we had a medical report from St. Joseph's Hospital and Medical Center that said her evaluation was normal, we would not have to present that to the grand jury. Why? Because it does not directly negate guilt. It feels like it does. It sounds like it should. But as you will learn later, or may have learned already, medical evidence is very rarely found in child abuse cases. You can digitally penetrate a child, and there can be no residual. There can be no evidence, no injury at all. It is tempting to believe that there should be injury. Most people think that there must be injury, but that is not factual. That's not consistent with what we know about the molestation of children and genital injury. So you would not have to give that there. But if someone else confessed to the crime, or if the victim recanted, even though that, I'm not so sure you'd have to give that to the jury. Most prosecutors do. But that arguably directly negates the crime. If the kid says it didn't happen, if true, then it didn't happen. So that directly negates guilt. I withdraw that. It directly negates guilt. But there are very few pieces of evidence that directly negate guilt. So it's the prosecutor's show. There's no defense lawyer. None of the witnesses are challenged. The rules of evidence don't apply. Hearsay is fully admissible. Typically what happens is the case detective comes to the grand jury, and she testifies about the investigation. If there's any questions at all beyond what the prosecutor asks, it's one or two from a juror on the grand jury. And the prosecutor can shoot down those questions if they want to, provided there's a reasonable basis. One that I commonly put a stop to is when, and jurors, you can understand why, jurors go, well, did the defendant say anything when the police pulled him over? Don't answer that question, detective. You're not to concern yourself with whether the defendant said anything in his defense or against his defense. I'm not saying he said anything. I'm not saying he didn't say anything. I'm telling you that it is irrelevant as a matter of law. You need to look at the evidence and decide whether there's a prima facie case. That's the standard in grand jury. Is there evidence, what we call a prima facie case, probable cause that the case happened the way the prosecutor said? So there's no cross-examination. The defendant doesn't get to testify. There's no lawyer for the defendant. All the rules of evidence don't apply. Hearsay is admissible. Inadmissible evidence is admissible. Sometimes grand juries do no-bill cases. Sometimes prosecutors go back and try again. But after a while, what's the point, We had one recently where a girl who was 15 and a half, maybe 16 years old, began chatting with her music teacher, and I mean in the digital form of chat on the internet, and communicating with him, and eventually she caught a bus to go watch him play sax at a club in Manhattan, and then he had intercourse with her somewhere a couple of times. Well, the grand jury did not want to indict her. Now, I'm told that this happens in some counties all the time. They didn't want to indict. They were more comfortable indicting him for official misconduct rather than the sexual assault. The sexual assault was a better charge for him if he ultimately was prosecuted, because the official misconduct now has some very draconian or severe consequences now. Official misconduct has really been changed to be very severe. The sentencing rules on official misconduct. But in any event, they wouldn't indict for sexual assault. They no-billed it. So we waited. We went back to a second panel. And the second panel no-billed it. And then we said, okay, we gave up. It's the end of it. I wonder at times, the grand jury merely is a screening process. Guilt or innocence isn't going to be decided. The teacher isn't going to jail for 20 years. There is a whole process, as I just explained to you, that can go on for years of representation and dialogue and discussion about this case. But to simply, at the beginning of the case, say, we're not going to charge him, because the inference that, I didn't present the case, but my colleague did, but the inference that the prosecutor drew from listening to the grand jurors ask questions was that the girl was old enough, she went along with it, she went to meet him, that somehow some of the responsibility ought to be hers. And that's what we call, especially when it happens in the trial context, nullification, where a jury, in this case a grand jury, has the power to nullify the laws of our community. Because it's a crime, and whether she drove there, took the bus, whether she was partially responsible. And I think partial responsibility really misses the point. I think it really misses the disparity in bargaining power and relationship and position. That's a different issue. You can't make those kind of arguments to the grand jury without turning into an uber advocate. But even assuming that that was meaningful, her participation in the crime, even assuming that was relevant, it still was against the law. And those kind of things could have been evaluated, and whatever mitigation there was, whatever lack of responsibility the accused had, would be evaluated and discussed and be part of the outcome in the prosecution stage. But it is what it is, and he was no guilty. And I think sometimes these grand jurors in a case like that are under the erroneous assumption or perception that the civil system or that the schools or the school boards will take care of this thing and there will be, consequences. Well, that is not always the case. Somebody's got to prove it to the school that this happened. So that's not a given. By far, it's not a given. That now, they'll take care of this, he'll lose his job. Really? Huh. And I can't call it naive because the average people aren't even in a position to know this. I think to call someone naive requires that they at least be in a position to know something, yet don't know it. I mean, the average person really, is not in a position to know how school boards act and what the requirements are. But that is misinformed, clearly. But we went back. That's the point. You can go back to the grand jury, among others. Let's take a look, and this is a clip from one of my favorite shows, The Law and Order. I'm sure you watched it online because I gave it to you to watch. And it shows the grand jury in action. It's in New York State. And they're a little bit more formal there. The process is the same. And maybe not more formal. I guess I shouldn't say that. But this is very typical of grand juries around the country. I think this was a motorcycle biker gang situation where I think the witness may have recanted on the stand. But McCoy is the prosecutor. This is a grand jury proceeding. And you'll see that he's the only one there. There's no defendant. And there's just a witness on a stand. And he's the judge and everything else.
Yeah, I was standing at the bar, so were a lot of people.
Like who?
Spaceman, Super Steve, guy named Ed.
What about Thomas Bell and Caridad Montero?
They were there.
And Daniel Smith, otherwise known as Igor?
Him too.
Did he say anything to Mr. Bell or Ms. Montero?
Might have.
Let me remind you, Mr. Stillman, you answer these questions or you will be held in contempt.
Yeah. Igor said something to the kid. I didn't hear what he said.
Did Mr. Bell say anything to Igor?
I couldn't hear.
Did you see his lips move?
My view was blocked. People were standing around.
Around his face?
The collar of his jacket was up.
Did Igor touch Mr. Bell?
Not that I saw.
Mr. Stillman, did Igor kill Thomas Bell?
Nope.
If your view was blocked, how can you be so sure?
because I killed him.
You know a biker named Stiletto?
That's what he calls himself. Others call him Stinky.
Did you see him in the bar that night?
Yeah. So?
He says he killed Tommy.
But he doesn't have the guts to kill a cockroach. And if he says he did it, it's because Igor and his friends made him. He is just as scared of them as I am.
Fine. You're testifying tomorrow.
The can opener thing was on the bar. Igor picked it up and stuck it in Tommy. I saw him. Then I ran out. That's all I know.
Thank you, Ms. Montero. I have no further questions for this witness. Yeah, Mr. Lang?
I have a question for this witness. She said she recognized this guy Igor because he was her old boyfriend. Did they part on good terms or what?
As your legal advisor, I instruct you the question is immaterial, and I decline to pose it. Ms. Montero is excused, and we'll take a little break.
Mr. McCoy,
Yes.
the reason I asked,
We're off the record now, Mr. Lang.
it's fine with me. It's just some of us aren't so sure about this Igor. We're still thinking maybe it's the other one, that one who confessed.
Okay, thank you.
You think that question is a lucky guess?
You're kicking all the tires. The confession does make an impression.
You want to take it to a different grand jury?
No, I'd like this grand jury to hear a completely convincing account of how and why Igor did it, because that's what I want to hear.
So you see from that one clip a lot of the things I talked about, and that's why I like that clip. Now, McCoy didn't put the guy in the biker jacket on the witness stand because he had evidence that directly negated the guilt of the person under scrutiny. I'm not sure if it was Igor or whoever, but they were both surprised when he accepted responsibility there. But if they knew beforehand, that would be an example of evidence that they have to present to the grand jury that someone else accepted responsibility, even if they don't believe it. And clearly they don't. Because the next day, what did they do? They brought in someone who saw it and testified that the original person under suspicion that they impaneled the grand jury to investigate is the one who did it. That was the young lady on the second day of grand jury testimony. And you saw a grand juror ask a question. And you saw the prosecutor, who's in complete control as your legal advisor. Now, I'm not so sure McCoy was right there, because that was a question about bias or interest. Didn't she say that she used to go with?
It's her ex-boyfriend,
Who was her ex-boyfriend?
Edgar.
Igor, or Edgar. Igor?
So the
Who's
guy
the
who-
accused, right? Not the
Right.
guy, the bald guy with the jacket,
Right.
but the guy who's accused.
Yes.
Right. That seems to me to be very relevant, because if they parted on bad terms, she could be. But again, he may be right though, because if you start getting into biases and those kind of things, you could be there all day. And those kinds of rules of evidence that are applicable in the trial courts, they're part of the foundation of the criminal trial. They're one of the more important aspects of cross-examination, and they're related to the Sixth Amendment. But in the grand jury, like I said, all of the rules don't apply, so that may have been the right call. I take that back, McCoy. Take it back. You are wiser than me still. But I'm sorry, you looked like you wanted to add to that.
Oh, no.
You didn't want to add to your observation? Anyway, McCoy says, you're not going to answer that question. It's immaterial. So he's in control. And then they get blindsided, and they go find another witness to complete the record. And they put her on the stand. And then co-counsel, the other prosecutor at the grand jury, is that Angie Harmon or whoever that is, the actress, she says to him, what? Do you want to what? When it looks like this grand jury's slipping away.
Pick another panel.
Go to another panel. And that makes the point that I was making earlier. You can go to a different panel. And you could represent cases. Any questions up to here, or anything that video suggests, or any questions about my lecture so far? Yeah, Dave.
Just how, in the case of John Gotti Jr.,
Okay.
had a case like that, clear evidence, and pretty much so many things against
Yeah, I didn't follow that case day to day, nor did I, read newspaper accounts. So I'm not sure how persuasive the evidence would be just from newspaper accounts. I thought it was a racketeering prosecution, which is a lot easier for a prosecutor than a substantive offense prosecution. By racketeering, it makes it easier to get in evidence. It's akin to a conspiracy charge where you kind of prove that people were involved in group activity that had a certain result, rather than have to prove that that person actually did the result or was closely involved in it. It's a little bit different and typically easier to prove. You may hear the term RICO, racketeer and blah, 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 RICO, which is the federal statute. But anyway, I think John Gotti Jr. was charged under that. I'm not sure what the facts were. I think he was tried 3 times, and the most recent was the 3rd, maybe the 4th. And that isn't a grand jury. But if there's a mistrial or a hung jury, which means that if the entire a conviction has to be unanimous, 12 people have to all agree that John Gotti Jr. committed murder or was part of a racketeering network, or whatever the charge is. If 6 of them think he's guilty and 6 of them think he's innocent, or 7-5, or 11-1, or 10-2, doesn't matter, and they cannot reach a verdict, it's what we call a mistrial, or a hung jury, and then the judge declares a mistrial, the case is over. But the prosecution gets to try the case again. It's not double jeopardy. If the case is tried to completion, then the prosecutor can never try the case again, like the OJ case I think I mentioned last week. So in Gotti Jr., they couldn't get a unanimous verdict 3 times, maybe 4, I don't know, we can look it up. But, what's the reason for that? It's hard to say. I'm not so sure that the evidence was that strong. May have been strong, felt like it was strong, but the newspaper might have reported, might have made it feel like it was strong. There may be 1 or 2 people there who will just never convict, an Italian or something, or a guy from Bensonhurst, or a guy who wears glasses. And, jurors, it's hard to believe that would happen 3 times. But if you get a loose cannon on a jury, or a wingnut, or a person that's just not normal, then you get a mistrial, and they will not change their mind, and they're pig-headed, and they're deciding the case not on the facts, but on whatever bizarre worldview they have. Then it's a mistrial. But for it to happen 3 times, you got to believe, David, there was something fundamentally wrong with the prosecution's evidence. You got to believe that there was just something, and I don't know what that thing was, because I didn't watch it closely enough. I mean, they got his dad eventually. Go ahead.
For the grand jury to return a no bill, how many members of the jury is supposed to?
Oh, that's a great question. How many members of the jury have to vote to return a no bill? That is, take no action, case is over, charges are dropped, essentially. Unanimous. It's a unanimous verdict. Majority. Did I say unanimous?
Yeah.
No, not unanimous. Majority. Majority rules. Majority rules, one way or the other. Majority rules. And you need a quorum, you need a certain number of jurors to be there. Because it's rare that all 23 are there on the same day. Sometimes, but not always. So once the grand jury hands up an indictment, then the case moves forward and is placed on the trial calendar, and that process I described at the beginning of class ensues. Every 6 weeks of discussing the case and trying to work out a compromise or a plea bargain, or going to trial. Go ahead, Latoya. Restriction on contact? Well, judges can attach to bail a reasonable condition, and if you are out on bail for a crime that involves drugs, and you have a prior drug history, a judge may say, okay, I'm going to allow him to go out on bail, but because he did this crime allegedly, when he was high on drugs, I want him to have drug and alcohol rules, which means that they'll be tested periodically. More commonly, a condition of bail would be you need to stay away from the victim. Do not contact the victim at all until this matter is resolved. That would be a condition of bail. One of the very common ones in child maltreatment is no victim contact. That would be a restriction. Is there a specific one you're looking at or a passage that you're referring to? Well, I'm sorry, where are you?
On 1 and 2 for B.
Is that an article? Where are you? What are you looking at?
At the very bottom for the rights to know before conviction, B, section B.
I'm sorry, look at the computer up there. What am I doing? Where am I clicking? I don't know where you're reading from. Is that an article or is that the...
NJR.
Oh, the statute? New Jersey bail criteria? Okay, sorry. All right. Restrictions on contact. Okay. If the court imposes conditions of bail that include restrictions on contact between the defendant and the defendant's minor child, a copy of the order imposing the restrictions shall be submitted to the family part. Such restrictions shall not affect contact authorized by an order of the family part case after any restriction on contact was imposed as a part of a bail order. It's a great question. I'm going to address it in 1 second. I want to get a drink. Believe it or not, this particular section of bail regulations was very recently enacted. And I had the opportunity to deal with this a few weeks ago around Christmas time, although we didn't quite get involved in this part of it. But typically what happens is if it involves an incest case or intrafamilial abuse case where there's concurrent jurisdiction, that is, there's jurisdiction by the family court as well as the criminal court, and the division through the Attorney General, or the family court, perhaps through a domestic violence proceeding or otherwise, is involved in the case. And the criminal court judge says, no victim contact, Dad. You can't have contact with your daughter. This says that if the family court evaluates this subsequent, after the criminal court imposes a no victim contact, the family court trumps the criminal court. Used to kind of be the other way around. Not used to kind of be, that's really formal speak. But very rarely would family courts get involved in contact between the defendant and the minor victim. Now, this requires notice to the prosecutor and a hearing if the prosecutor wants it, because they realize, the drafters of this, and I did a little research on this, there was a committee, and Judge Karchman was involved, and a couple other judges, I think, but I know there was a committee that suggested this because there would be conflicts from time to time between the family court, and the family court would say, hey, we're doing all this stuff designed to keep at least some kind of relationship between the parties, including the defendant and his own family, despite the fact that he's accused of a crime against that child. We're trying to reunite people or start supervised visits or do things that are in the best interest of the child, believe it or not, but we can't because of the criminal courts. So there was a lot of discussion about this, and this law, or this bail rule, was changed. And essentially it gives the family court the right to carry the ball on the issue of familial contact after the bail condition is imposed by the criminal court. The prosecutor has a right to notice and to be heard and to object, because the thing you worry about is that contact undermining the prosecution and ultimately resulting in more danger to the child, even though the belief might be that it is a healthy thing for there to be contact, and it's the right thing to do. I haven't seen this in practice that much, where the family court is going to change the degree of contact or the quality of contact in a way that's inconsistent with what the criminal judge did. And I'll tell you a little bit more about that in a case that I had recently. In a moment. Any other questions? So, ultimately, yes.
Question, right? On the reading, it says that parole is involved in every aspect of the case when an individual is charged with something. So, would that involve would it be pre-bail or post-bail?
What's involved in every aspect? Parole
Probation, I think it is. Probation.
or probation? Well, yeah, probation is a department of the court, believe it or not. The probation department is part of the courts. So, very often the probation department does a workup, if you will, a report for the judge so that they can set bail. And in some states, they make a recommendation to the court about what bail ought to look like. They will get the police reports. They'll get a report about the family's economic circumstances, whether they own property, those kinds of things, because those are the things that the judge would need to know in order to set a bail. The probation department may even be the department that's monitoring the family, or the defendant, if they make bail, if they're out on bail, and they have conditions, if they have to do drug and alcohol testing while they're out on bail, somebody's got to go collect the urine sample and process it. That would be the probation department. So, the probation department can be involved from the first day to the last day. Because as you'll see in a moment when I talk about sentencing, they prepared the ultimate report for the judge on the issue of the defendant's background, involvement in the current crime for which the court has to sentence the defendant, and their family situation. They prepare a thick report for the court to read in order to make an informed decision about sentencing. And that's the probation department too. And they also are in the business of monitoring people on probation, which I'm going to mention in a moment as well. Okay? Did I answer your question?
Well, how soon after, initial arrest do they need to have the report prepared for the judge?
Well, they're involved the next day sometimes. Now, in Passaic County, I think it's the criminal division, but they're also part of the courts. So I'm not so sure it's the probation department, which is part of the courts as well. It might be the criminal division of the probation department. Looking on the court's family tree, if you will, I'm not sure how it all fits together, but they're both arms of the court, probation and the criminal division. The criminal division, I think, is part of the probation department. So yes, probation. Could be the next day. If the guy gets arrested now at 7:05, 10 o'clock in the morning, the judge wants the probation department to prepare a report about as much as we know at the moment about this case and this guy, so I can set bail. And then all the way at the end of the case, probation department is involved as well. So, the defendant doesn't want one of these plea bargains, doesn't want to admit his guilt. You cannot accept a plea of guilty from someone who will not admit their guilt in New Jersey. Some states have a plea of, can someone tell me? Maybe you heard it in the popular media. What do they call it? A plea of no contest. Nolo contendere, or something to that effect. What that means is I'm not going to challenge the prosecution's proofs. I'm not saying I did it. I'm not saying I didn't do it. I'm not saying nothing. But I will accept responsibility and the consequences associated with this offense. We don't have that in New Jersey. You must provide a factual basis for your guilt in New Jersey. Okay? So you got to tell the court that you did it. So, if you have a person who refuses to admit they're guilty, in fact they are, or is in fact not guilty, there's going to be a trial. And the way the system works is the prosecution gets an indictment. The defense gets their discovery. The prosecution gets their discovery. They cannot reach an agreement. There's no plea bargaining. Pardon me, there's no plea bargain. There's going to be a trial. And the way you do that is the defendant is either represented by private counsel or by the Office of the Public Defender. In every state in America, there's an Office of the Public Defender, which provides free or low-cost legal representation for persons accused of crimes. The first step in a criminal trial is jury selection. Jury selection. Both the prosecution and the defense get to challenge jurors. By challenge, we mean get to ask the court to eliminate a juror for no reason whatsoever. That's part of the jury selection process. So imagine this classroom filled with 140 people from Union County, and I am with the Union County Prosecutor's Office, and we're going to select a jury. And seated next to the defendant, Roger Redden, is his attorney, Kalman Geist. Kalman Geist is Roger Redden's lawyer. In this case, I will get to challenge 12 people. 12 people without giving a reason. Roger Redden will be able to challenge 20 people without giving a reason. I'm not sure why the disparity. I never really looked it up, but since I started trying cases, that's what the rule is. We don't get as many. When I say we, the prosecution doesn't get as many as the defense. There are these limitations. You cannot strike jurors. You cannot eliminate jurors with these free challenges that you don't have to give an explanation for. You cannot eliminate jurors solely based upon their race or ethnic background or gender. You may think it's highly relevant. You may have a Peruvian defendant. And you may be so sharp that you can spot Peruvian Latinos on the jury by their name or by their look. Or you may think you can spot Peruvian jurors. You cannot strike all Peruvian jurors or persons who you believe to be Peruvian. Because the theory is, no one's suggesting that there isn't some logic to this, but it's not a valid reason. It's not a constitutionally valid reason, that's for sure. It's not a legally valid reason. But the belief is that a Peruvian juror might be sympathetic to a fellow country person. Right? You know, we talked about this judge who's trying the case in San Francisco about the constitutionality of the California Constitution, and right when we were here last week, I was looking around, it turns out that he's a gay man. Now, most people, if not everyone in the legal community, says, well, that's not relevant. But people who aren't in the legal community, some people think it is relevant. One could see why it might be relevant. The assertion is that he may be more favorable to the position of the advocates for same-sex marriage. Wouldn't be a crazy proposition, right? Now, that's a little bit different. He's the fact finder. He's the judge. It's a little bit different. So I'm not so sure what direction that issue's going. Well, when it comes to knocking off jurors, you cannot knock them off based upon gender or race or ethnic background. But you can knock them off because they read the New York Post, or they wear hats, or they don't like the length of their fingernails. Now, you could say those kind of things, and back in the day, that could be your reason. But now, because of suspect jury challenges, you need a little bit more than that. You need to say why. Well, let me tell you, Judge. Women who have very well manicured fingernails, in my experience, tend to think like this, and to think like that. Or they have a different belief than some person who didn't have finely manicured fingernails about scratching someone during an assault. You know, you need to come up with some meaningful basis for your challenge. Now, you don't have to explain your challenges every time. Otherwise, you really wouldn't get 12 and 20. You can challenge people for no reason at all. If every time you challenge somebody, you've got to come up with a reason, then they aren't challenges without cause. They're what we call challenges for cause. But what happens is, you know, if you challenge 2 or 3 women and no men, and then you challenge your 5th woman and your 6th woman and no men, the defense is going to say, Judge, I want to be heard. I see that Del Russo has challenged 6 women here. Every one of his challenges have been women. And I think he's doing it for A, B, and C. And at that point, I ought to be able to, I'm going to need to be able to explain my mindset for challenging those women, beside the fact that they're women. Now, the way I do business, and the way I think most professional lawyers would do business, so to speak, or conduct themselves, is everybody I challenge because I got a belief about why they would be adverse to my position, and more likely to embrace the defense's position. So the days of just knocking someone off because you don't like their hat are over. And those aren't good reasons anyway. Now, you might say, hey, a person who wears a hat and gloves, now this goes back to the 60s and 50s, very few women wear hat and gloves anymore. But in another era and another day, where Sunday you wore a hat, when I was a kid, you had to wear a hat to church, I remember. And gloves, I don't know if you had to wear gloves. To church. But in any event, you know, in the 50s and 60s, if somebody wore a hat, you would say, well, they're conservative. They have a certain worldview. They grew up in a different era. And that might be important to you, and that might be relevant. If you believe that a conservative, a person who believes in rigid morality and strict mores in society, might think one way about this case rather than another way. So the way we carry ourselves, whether you're carrying the Post or the New York Times, says something. You know? I like to carry both. I don't know what that says. In any event, you get to pick a jury, 12 challenges and 20 challenges, and it varies depending upon the kind of crime. And then you can challenge someone for cause at any time. If someone, as I see from time to time, was a victim of sexual assault or even incest, you know, the defense will say, Judge, this person has to be stricken for cause. And what that means is that person's background or experience so affects their ability to fairly and objectively and logically evaluate the facts in this case that they ought not be permitted to sit. And a defense lawyer would say, listen, Judge, this girl was molested by her father. How could she sit in judgment of Roger Redden, who's accused of molesting an 8-year-old girl in this case? She may say she can be fair and impartial and only decide the case on the facts. But nice lady, Judge. Nice lady, but she doesn't know what she's getting into. And I don't believe anyone who lived through what she lived through could ever be fair. And many judges will agree. Some won't. Some will say, use one of your challenges. Everything you're saying is persuasive, but I'm convinced that she will be fair. Use one of your challenges. Some judges will say, I agree. How could this woman be fair? The court will just excuse her. They call it excuse. The court will excuse her. And that means that it doesn't come off the 12 and 20 that the lawyers have. And you get a lid, you get a pencil, and a checklist, and we're writing things down, making arrows, and just all kinds of judgments very quickly. 5-second judgments on people. What do they care? What's that book? I can't see. Let me drop my pencil. John Grisham, huh? Someone thinks they're a lawyer, huh? Okay. The reason why we question jurors and dismiss them or embrace them is because we want to make sure, when I say we, the system, the civil system, the criminal justice system, we want to make sure that the jury that decides the facts in this case decided solely and only on the facts, only on what they hear, only on the evidence that's persuasive to them, not on their emotions, not on their personal beliefs, okay? Not on their biases or alliances to certain ethnic groups or things like that. Only on the facts. So what we try to do is we try to pick a dozen people who really know nothing about the case, nothing about the personalities involved, nothing about the social science, or any of the science, or any of the expert issues that might be involved in the case. We want them to be a blank slate, essentially. Now, nobody's a blank slate, but we try to minimize the potential for persons to be on a jury that might have a particular bias towards one party or the other. So if there's going to be a lot of police officers to testify in a case, then persons who are the children of police officers, who come from a family of police officers, they might not be the best jurors. And one of the standard questions is, because many criminal trials involve police officer testimony, one of the standard questions is, are you or any member of your family, question 12, a member of law enforcement or ever been involved in law enforcement or blah, 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 and on and on. It's all about law enforcement. And law enforcement is broad enough to include the Municipal Police Department, the County Prosecutor's Office, the United States Attorney's Office, the Bureau of Tobacco and Firearms, Homeland Security, the FBI, the CIA. And the people answer that question. Have you ever been a victim of a crime, or has anyone in your immediate family been the victim of a crime? Why? If you were recently the victim of a home invasion, where masked gunmen came in your home and were trying a robbery or even a mugging, we want to know that, because the defense is going to say this is a person that's very traumatized, who was very scared about what happened to them, and they may be here ready to take it out on the next guy. They may take out all of their emotions and anger and vulnerability that they feel on this guy who's accused of a burglary or some other offense that's somewhat similar. So you need to know those things. And there's she says question 12, there's a bunch of questions that are standard, and then there's case-specific questions. Like, are you familiar with the area, 10th Avenue and Broadway in the city of Patterson? Are you familiar with, skeletal injuries? Do you know anything about radiology? Things like that. Maybe because this case involves the analysis of radiological films.
No, I'm just curious why they ask you. I think after, if you're a member of a police officer, the next question is, do you work for the state? Why would that matter?
Do you work for the state?
Yeah, the state.
I'm not sure. I don't remember that question, but I haven't picked a jury since 2007 or 2008, really. 2008, I last picked a jury, but they changed things in the past 2 years. The state, I'm not sure why. What kind of case were you on?
Oh, well, it was a drug charge case, but I got dismissed because I'm married to a cop.
Okay. Well, maybe. They didn't tell you that, did they? They just seemed like that was it, right? Because that came out and then you were dismissed. Go ahead, Daniel.
So have you not picked a jury since '07 because of plea bargaining?
No, I think 2008. No, because I'm the supervisor of a unit, and I don't have a large case calendar, so I try a case every couple of years. Sometimes I'll try 2 or 3 in a row. It depends upon the cases that I retain and whether they are coming up. You can go a year or two. My colleagues, Chris and Lisa, they try 2, 3 cases a year or more because that's what they do. But I got to do other things, supervise the unit, involved in policy and things like that. So that's kind of why. But although I have a trial coming up on May 3rd, that I think I'm going to try. So I'll be picking a jury again in a few weeks. In any event, so you pick a jury, and you wind up with a group of people that everybody has questioned and everyone agrees on for this case, on this day, with this group is the best possible group. You pick 14 jurors, typically. Sometimes 13, 14, maybe 16. I've had cases where we pick 16. Can someone tell me why, if you need only 12 jurors to decide the case, we would pick 16 jurors or 14 jurors? Go ahead. Yeah, nobody wants to try a case for 2.5, 3 months, and then juror 12 gets sick, and you only got 11 jurors, and at the end of the case, you got to start all over again. So you have 14, sometimes 16 people hear the same evidence, and at the end, only 12 will decide, and then others will be alternates, and they pick their name from a drum, or now the computer does it, and they pick 2 or 4 or 3 alternates. But yes, so you impanel your jury. You have 14 jurors that are going to hear the case. The prosecution goes first. The prosecution has the burden of proof. The prosecution has to prove the case beyond a reasonable doubt. We talked about burdens of proof, right? There's beyond a reasonable doubt, and there's a preponderance of the evidence. Preponderance of the evidence is more likely than not, 51%. Beyond a reasonable doubt is, as some might define, you are convinced to a moral certainty. I don't like that definition because the word certainty is wrong. There's nothing is certain in life. You don't have to be certain, but you have to have an honest and reasonable doubt that the person did it. But in any event, the standard of proof is significant. So the prosecution goes first, and they have the burden of proof. The prosecution puts forth evidence in the form of witnesses who were there, the victim, maybe medical reports, depending upon the case. So, for example, if it's a shaken infant impact syndrome case, or what we call shaken baby, what Anthony Galloway was charged with in State versus Galloway, that case would involve the testimony of perhaps the caregiver in the case, although she was charged as well, maybe neighbors who heard things. You would put on the triage nurse from the hospital when the baby died. You put on the medical examiner. And it would rely in large part upon expert testimony in the form of a forensic pediatrician or an expert in injury to children, child maltreatment injuries, things like that. So you would, in the case of shaken impact, you'd probably wind up with 2 or 3 experts. You'd probably have a neurologist testify. You'd probably have a radiologist testify, okay, to evaluate the film. The neurologist would talk about brain injury, and you might even have an expert in the injury to the eyes, because there was retinal hemorrhaging and those kinds of injuries, and then and perhaps an expert on child maltreatment who would talk specifically about the child shaken infant impact syndrome and how that works. And the prosecution, since they had the burden of proof, makes its opening argument. And that's how a criminal trial begins. The prosecutor goes first and tells what they expect the evidence will prove. Okay? And the defendant goes second, and his lawyer will typically speak directly to the jury in a very folksy way and highlight the fact that his client is presumed innocent, that the entire burden of the prosecution is on the state. It's not on his client. His client doesn't have to prove anything. That's a wise lawyer who opens up that way, because you never want to talk about facts, because you don't have to prove facts. And you don't want to make an assertion about the facts that may not prove true. Because if you lose your credibility with the jury, you lose it all. So defense lawyers, the good ones, will almost always stay away from the facts, unless there's something that's very important to their case that they need to highlight right away. But that's very rare. Prosecution needs to talk about the facts. They need to tell, what they're going to prove. What they're going to prove. Now, I favor, although some lawyers have a different approach, I favor telling what happened in a narrative, if you will. I prefer telling the story of what happened as if I was there. Now, you don't say it that way, and you need to prove all of the elements of the crime that are contained in the indictment. And you cannot ever say that you were there, but in the narrative, in the way you approach the jury, you can gain that advantage and lend whatever credibility that your presentation provides to the ultimate guilt or innocence of the defendant. So some people talk about the indictment, and they start out by saying the indictment charges Anthony Galloway with committing the crime of murder, namely by taking the child and shaking him to death. That kind of stuff to me is boring and, although relevant, not something you want to do in your opening statement. Your opening statement should capture the facts that are relevant to the elements of the offense, but should do it in a way that I think is compelling, that connects with the juror. So you say things like, it was a rainy night in Galloway Town, State versus Galloway, the defendant. It was a rainy night in Atlantic County. Anthony Galloway was watching the Rams versus the Chargers. It was about 4:30 in the afternoon. And little Daniel began to cry. And Galloway told him, "Shut up!" But he wouldn't stop. Then he walked over to the crib and he waved his finger at little Daniel and said, "Shut up, I'm trying to watch the game." And he went back and he watched a little bit more of the game, but it wouldn't stop. The baby cried and cried and wailed and cried. Anthony Galloway got up the last time and we never heard from Daniel again. Because he walked over, ladies and gentlemen, to that crib and he grabbed that little pound-and-a-half baby and he took him by his little ribs and he shook him back and forth until his little brain spun off on. And you tell the story, and he threw the baby down and he killed the baby that day, and he is responsible, and you want to get near him, and you want to kind of point to him, and you want them to look at him when you tell the tale of what happened. It's not a tale when you tell the story of what happened. Now, the defense is not going to bite on that. They're going to come up there and say something like, Mr. Del Russo tells this as if he was there. He wasn't there, ladies and gentlemen. He has no idea what happened that day. My client, Anthony Galloway, sits here today, an innocent man. And you need to look at every piece of evidence in this case, remembering that presumption of innocence. Because, number one, he is presumed innocent. The judge will tell you he's presumed innocent, but I'm telling you something more than that. He didn't do it. It didn't happen. Everything Del Russo says is wrong. My client, Anthony Galloway, did not hurt that child. That child was the apple of his eye. The day he was born, he embraced his wife and he told her this, that, and the other thing. He would never hurt that child. Every day he cries in his bed at night because he lost little Daniel. And you have both sides given. The opening statement tends to have a flourish, depending on who's presenting it. the defense will emphasize prosecutor has the burden. My guy didn't do anything. They have to prove it beyond a reasonable doubt. That's what makes this country great. You know, the flag, apple pie, and the presumption of innocence. You'll hear all about that, and then you gotta produce. Then you need to put witnesses on. Then the jury needs to hear from the witnesses, and that's what happens. The witnesses testify, the experts will testify. The defense gets the opportunity to cross-examine those experts, to challenge them based upon their Sixth Amendment right, correct? The Sixth Amendment right to challenge the evidence. One of the great ways to challenge evidence is through cross-examination. The purpose of cross-examination is to point out a variety of things. Number one, you want to expose bias. If a witness is friendly with the prosecutor's witness, or if a witness knows one of the prosecutor's witnesses, or if a witness has a stake in the outcome. Let's say it's the mother of the victim, and it's a sex case, and the accused is a neighbor. Well, the mother of the victim has an interest in validating her daughter's experience, right? So there's some bias. She's going to want to testify favorably for the government, the defense would argue, because she wants to see this guy punished. This guy that she wrongly believes molested her kid. So any connection to the prosecution's case needs to be exposed that might demonstrate bias or interest in the outcome. That's just one thing that we look for, or that lawyers look for on cross-examination. The ability to recall events, whether something limits that ability to recall events. If a witness has, trouble remembering things, or if they are an eyewitness, or they watch something or observe something and have difficulty seeing, or if things were far away, or if they were looking at things from a particular perspective or vantage point. Those things would be exposed by one lawyer or the other. They would ask about body position, where you were standing, how long you observed something for. Now you say the person pointed the gun in your face. And at the time he pointed the gun in your face, you were looking directly at the gun. Isn't that a fact? Yes or no? The defense and the prosecution, but lawyers who cross-examine, use lots of yes or no questions. And they're allowed to. Because they want you to either agree or disagree, you don't have to agree, with the proposition that they are putting forward. Now in that case, a defense lawyer might say, well, it's fair to say, Miss Victim, that when this person entered the bank, they put the gun directly in your face, because that's what you told Mr. Del Russo. Is that correct? Yes or no? Yes. And you said that the person was in front of the teller window for about 15 or 20 seconds. Isn't that what you told Mr. Del Russo? Yes. They'll ask a string of questions that are basically already asked and answered. And it's fair to say, Miss Victim, that you were looking directly at the barrel of that gun. Is that right, Miss Victim? Yes, of course. You have never been robbed at gunpoint. Isn't that right, Miss Victim? Never. No, you never had a gun pointed in your face before, have you, Miss Victim? No, never. I imagine it was terrifying. Isn't that right, Miss Victim? Absolutely. Now, what the defense is trying to do is show that she's focused on the gun, not the head, not the face, not the person. So that's one way of, in a world of a million different ways to challenge or cross-examine witnesses. But the point is, you ask witnesses questions in an attempt to clarify, to put it objectively, clarify what they saw, what they heard, what they smelled, what they tasted, what they observed. To put it in context. Now, the defense lawyer wants to undermine the state's witnesses. Okay? Wants to show that they really didn't see exactly what they claim they see, or what the prosecution wants you to think they saw. They want to show that this person has a stake in the outcome, that she might color her testimony to favor the prosecution because of this, that, or the other thing. So both sides do that. Once all the evidence is in, then you have the closing arguments. The defense goes first with the closing arguments, and the prosecution goes second. And those closing arguments are the place that the lawyers get to tie it all together. The jury heard all the evidence. Now the lawyers say what the impact of that evidence is, or what they believe you ought to infer from that evidence, what the jury ought to think about all that evidence. And of course, the inferences that the lawyers want you to draw are going to be very different. The defense is going to get up there first and say why the prosecution has not proven their case. They have not met the burden here They will hammer and hammer and hammer reasonable doubt all day long, and they should. They should, because that's something that jurors pay close attention to. It is the law, and it is something that is very elusive. It's hard to wrap your arms around reasonable doubt. And if you want an easy way out, jurors, reasonable doubt's the answer. So if this juror's just not so sure, this jury's not so sure about which way they're going, reasonable doubt will take them to the promised land of defense. So they'll talk about that. Ladies and gentlemen, you cannot convict my client Anthony Galloway because you think it might have happened. You can't convict him because you think he's the kind of guy who might have done it, or he looks like the kind of guy who's capable of doing it. You can't convict him because of any of those things. You can only convict him if Mr. Del Russo has proved his case beyond a reasonable doubt. You have to go back to that jury and say to yourself, beyond any reasonable doubt, I believe Anthony Galloway shook little Dan to death. That is your charge. That is your duty, to believe and be convinced beyond a reasonable doubt that this man killed that child. And it didn't happen, ladies and gentlemen, not even close. But I'll tell you this, Del Russo did not prove this case beyond a reasonable doubt. If you listen to the medical examiner's testimony again, and you think about what he said, this was inconsistent with that. The expert on shaken baby syndrome said there could be 50 reasons why this could have happened or that could have happened. There's so many places, ladies and gentlemen, that there's reasonable doubt, and he wants you to put him in jail. Then, of course, the prosecution wraps things up, and they tell their version of what happened based upon the evidence. And the good news is, for the prosecution, is you can address some of those things the defense lawyer brings up. You don't want to spend your whole summation dealing with what they said, because in some ways it kind of validates their position. Seasoned prosecutors are kind of dismissive. Maybe they made a little headway with one of their arguments, and you want to address it right away. You say, listen, ladies and gentlemen, I want to stop Mr. Geist right here and now with that argument about X. That's not what the pathologist said about DNA. That's not even close, and here's why. Now let's get back to what Mr. Galloway did that night when he was watching the Chargers and the Rams. And then you go into your thing, your summation. Then, of course, the jury deliberates after the judge explains to them for which can be hours the law on the subject. And then they decide whether guilt or innocence. And again, like we said earlier, a dozen people have to decide unanimously on every element of the offense beyond a reasonable doubt that the defendant is guilty of the crime. One of the things that give the prosecutor, at least in New Jersey, a bit of an edge is these notions of primacy and recency. That is, people remember or are more influenced by or is more impactful the first thing they heard or the last thing they heard. And that's something that prosecutors have in their favor, if that's meaningful at all, that psychological dynamic. Prosecutor goes first, and they get to go last. And then the jury decides it, and if there's an acquittal, as we learned, that's the end of the case. If there's a conviction, well, it goes on through the appellate review. Any questions about that? So that's where Roger Redden has his trial, and ultimately there's either a conviction or an acquittal. Now, I was really... well, we'll talk about that in a minute. Once someone's convicted, not everyone goes to jail. So you could be placed on probation instead of jail. Probation is something that you get instead of jail. In some cases, you can get probation with a little bit of jail, up to 1 year in jail. Anything over 1 year, you have to go to state prison. Anything less than 1 year, you can be placed on probation and serve some time at the local jail in the county. So you can wind up with probation as well as some jail time. There was a Passaic County jurist who used to say, you get a little taste. You get a little taste of the criminal justice system and specifically incarceration. So, but in most cases, Probation is something that happens instead of jail. Probation is where the court lets you be at liberty in the community, provided you live up to certain rules and regulations and conditions. The first of which is you're supervised by an agent of the court, a probation officer. You're supervised by a probation officer. And that probation officer has you report to them periodically. Could be once a week in the beginning, maybe twice a month, maybe once a month, depending upon the crime, how you do on probation, and how long you're on probation. So the probation officer will monitor you on probation. There can be conditions to probation. Just like we talked about bail conditions, you will see that there are conditions that can be placed on probation as long as they're reasonable. Some typical conditions include no victim contact, drug and alcohol rules. That means you might have to have periodic drug testing or periodic alcohol testing. Can someone tell me another probation condition that might be attached to someone's liberty or release in lieu of prison? Danielle?
Working employment.
Maintain full-time employment could be a condition. David?
I gotta wear a bracelet.
What's that?
Bracelet.
You may have to wear a monitoring bracelet. Could be. Yeah, Danielle?
Education, such as GED.
They may say you have to either be in school or work, or I want you to go get your GED or at least work on your GED. Adrian?
They could say not being in contact with whatever criminal element got you into trouble in the first place.
That's right. You could be ordered to stay away from gamblers or gambling, or stay away from bars or alcohol, stay away from drug areas, those kinds of things. Danielle?
Paying a fine.
A fine can be a condition of probation. Latoya?
You could be ordered to attend drug and alcohol treatment.
You could be ordered into drug treatment or alcohol treatment. Excellent.
Like counseling, to go to counseling.
Mental health counseling, psychological counseling,
Domestic violence.
domestic violence counseling.
You could be ordered
Jacqueline?
to stay in the state, but you can't leave the state.
Can't leave the state without permission. Anger management counseling. Community service, which means you may have to work in a hospital ER or pick up garbage along the parkway, or clean up the library grounds. Parenting classes in the world of child maltreatment, that would be an excellent example. Parenting classes, anger management, those kinds of things. Excellent. What are others? Well, I think you hit on them, a lot of them, Jack.
Supervised visitation.
You may have to have visitation supervised or monitored if you have visitation at all. All of these can be conditions of probation as long as they're reasonable. What about if you were downloading child porn? No computer use, limited computer use, maybe have software installed on your computer to monitor your computer use. Things like that in this era. So, parole is different from probation. Remember, probation is instead of jail. Parole is after jail. After state prison. Parole is a process of supervision after you serve your sentence in jail. Okay? One of the arguments, one of the articles I gave you is called The Innocent Prisoner's Dilemma. And I gave it to you because it gives you a great summary of the theory and history of parole, its historical origins, and the purpose of parole. And the hope is that parole can facilitate reform or reformation. Remember, this is a person who's committed a crime, who is a person who violated the social compact that we have. Now, whether someone is granted parole varies from jurisdiction to jurisdiction, but the article from MedWed describes some of the common issues that parole boards look at. Because remember, when you're in prison, parole is a form of early release under supervision. And you can appreciate that it is important that there be supervision and the potential for early release. Yes?
If you don't get early release and you complete the entire imposed sentence, you can't get parole?
Well, there are still a significant class of defendants that have the ability to what we call max out. That's not exactly a good thing, maxing out, because then there's no parole. But there was a statute passed in 2001 called the No Early Release Act, and it abolished parole in a way in New Jersey for certain offenses, serious offenses. We call it the 85% rule. Everybody has to serve, if they're convicted of this group of crimes, 85% of their sentence. But even then, there is a transitional period of parole for the last 15% of the sentence. But technically speaking, you can max out and not have any parole. But I think that after the No Early Release Act in 2001, I think that that's not possible anymore. LaToya, sorry.
That's okay. In your opinion, right, do you think that there's kind of maybe like a shift where we're moving from the stringent checklist of who can have parole basis the discretionary decision of the board member who can have parole? I guess just based on the population increase in prison and the economy currently.
Well, look, parole boards are staffed by political appointees. The process is always at some level political. And I'm using that in the broader sense, not only Democrat, Republican, Independent, but the decisions of parole boards and their policies have to be reasonable and they have to be consistent with what the public expectation is. So I do believe that parole boards and their release decisions trend in the direction of what the public believes at any given moment. And I think after the murder of Megan Kanka in the mid-90s, that sex offenders had a tougher time being paroled than they did before the murder of Megan Kanka. And that's what I mean by they trend in the direction that public expectations are moving. So, I think the answer to your question is yes, they move, and decisions, despite the fact there are a number of objective criteria for deciding whether someone gets released, ultimately the decisions are impacted not only by those criteria, but also by the public issues of the day. Some of these criteria include the likelihood of recidivism, right? The public safety, how they did during their incarceration, their history of institutionalization. Were they model prisoners or were they in fights and starting fires and smuggling drugs into their cells? That's someone who is less likely to get parole. The nature of the crime, the criminal history. If they do get out, what are they going to do? Do they have a job prospect? Do they have a place to live? Do they have family that's supportive? What's their social history? How's their physical and mental health? Are they beginning to rehabilitate? What are the prospects for rehabilitation? All of these variables are relevant in whether someone gets paroled or not. And you can appreciate why there needs to be some sort of early release. Although people object to it sometimes and think that it is wrong to allow criminals to get out of jail early, just on the basis of managing a prison population, you might see why it is valuable for there to be the potential for early release. Remember, if you had a prison population of 6,000, 7,000 men, and every one of them was going to do their maximum sentence, and there was no way to get good time credits when you were in jail, there was no way to earn privileges, there was no way to earn good, favorable things by your behavior in prison, what would that be like? Imagine a building with 8,000 men, every one of whom will do their complete sentence, and all who are hopeless about ever getting out early. How could you ever enforce decorum, right? How could you ever manage the prison population? It is very effective to have a system of rewards. And jails and prisons do. They earn credits in the forms of days off their sentence. There's nothing more valuable to a prisoner than days and cigarettes. But not anymore, because believe it or not, you can't smoke in prison. So you need some sort of tangible reward in order to manage a prison population, in order to enforce and maintain order. It's very valuable. And it's consistent with rehabilitation, too. So any questions about parole and probation? Okay, the last thing I want to talk about is the actual sentence in New Jersey. And I already told you that at first degree, the sentence is between 10 and 20 years in jail. A second degree in New Jersey, we'll only talk New Jersey law here, 5 to 10 years in prison. Draw a line right there. First and second degrees are at the top of the sentencing hierarchy. Both of those offenses, if you're convicted or plead guilty to a first or second degree, 10 to 20 years exposure, second degree 5 to 10 years exposure, both of those offenses have a presumption that you will go to prison. A presumption. So if you're convicted of either second or first degree crimes, you're going to jail. In order to not go to jail in New Jersey, you have to be idiosyncratic. And that's a very tough standard to meet. The defendant has to be highly unusual, or the crime they committed to be bizarre and highly unusual. And that's very, very rare. So the presumption of jail applies to first and second degree offenses. The presumption against jail applies to third and fourth degree offenses. Third degree offense, 3 to 5 years in prison. Fourth degree offense, up to 18 months in prison. And if you're a first-time offender who commits a fourth or third degree offense, you are presumed to not go to jail. Believe it or not, that doesn't apply to county jail time as a condition of probation. The little taste I mentioned before. You can get probation with up to 364 days. 1 day less than a year in jail. As a condition of probation. That does not violate the rule that you shall not get jail. Not shall not. You are presumed to not get jail for third and fourth degree offenses, first time. If you have a prior conviction, then there's no presumption either way for third or fourth degree offenses. But a second and first degree, you're presumed to go to jail, unless you're idiosyncratic or your offense is idiosyncratic.
Okay, students who are listening to this in February
So
2011,
for first-time offenders who commit a
I'm
third
going
or
to
fourth
jump
degree
over to
offense,
another class where there's
you're
a
not
little
going
bit
to go
more
to state
lecture
prison,
for
let's
you.
call it. You might
And
go to
pick
the
that up
local
in a
prison
minute.
for a short time,
Okay, we're
but you
almost
won't go
done.
to state prison. We also
There's
talked
a
about
presumption
why
against
parole
state
is
prison
necessary for third and
Why you
fourth
need
degree
a
offenders.
system of
First-time offenders.
rewards.
If you have a prior felony conviction, there's no presumption either way for
Why
third
you
and fourth
need
degrees.
for
First and
the
second degrees,
inmates
you're going to jail.
to
Unless
have
you're a real
something to
oddball.
achieve.
In order to maintain order in the prison system. We talked a little bit about that as well. And I also mentioned that for most serious offenses in New Jersey now, they have abolished parole. And that's probably misleading. There's still a system of parole, but you have to do 85% of your sentence. Typically, offenders would get out in about 1/3 of their sentence. So if you got 10 years, you'd get out in about 3 1/3. Now, for many offenses, if you get 10 years, you have to serve 8.5, 85% of your sentence. So there's still some parole at the end because you need a transitional period so that that person can integrate themselves back into society rather than just open the door and pat them on the back and give them their duffel bag and their toothbrush and say, see you later. Even the no early release states, even the states that have abolished parole, have a period of supervision, community supervision at the end. And that's what probation and parole are, two kinds of community supervision. Right? Where you are out in the community being supervised by a government agency based upon a crime you committed. Excuse me. Probation in New Jersey is managed at the county level, while parole is managed at the state level. Although they're both state employees, the probation department is managed within the counties, while the parole department is managed on a statewide level. Lana, you had something?
I just wanted to know if there was programs out there for people who are on parole, like, because I see it like a mess. Like, say 40 people left out of jail and everything. There isn't a lot for these people to do, and especially since you're crimes. It's really hard for them to get jobs and things like this need, because, like, you can't find a job. People with degrees can't find a job. So then when you have somebody with parole, what makes the company want to take a chance on them? You have to wait like 7 to 10 years to do this, like, to even get it. What is going to do? I'm running into a lot of parents and people in the community that don't have too many resources.
Yeah, no one said it's going to be easy for a parolee to transition back into society, but it is difficult in any era, in any generation, more so in a time of economic downturn where jobs are less available. The parole officer, part of their role is to help you get housing and a job and to make that transition as smoothly as possible. But there are lots of difficulties associated with that. This week there was an article in the Bergen Record about the former mayor of the city of Passaic who just was released from federal prison, Sammy Rivera. And part of the article addressed the issues surrounding former Mayor Rivera's transition back to the community. And an advocate for parolees and prisoners was making the observation that Sammy Rivera has it far better than the average person who gets out of jail. He has a job waiting for him. He still has some capital within the community that is some level of standing. He still has a support group. He still has some friends and connections that he can use to help him get back on his feet, where the average person who leaves the prison system has none of those things. And apparently Sammy Rivera, had begun a job working at a Mexican food distributor because the owner was a friend of his from before he went to prison. And that kind of illustrates what this advocate was saying in the news article, that he has connections and relationships that he can use that the typical prisoner could only dream of. They even pointed out the fact that he arrived for his first day at work in a car. That is an advantage that many prisoners don't have either. They don't have stable housing. They don't have a vehicle. They don't have friends or connections or support in order to get back on their feet. So they are often placed in transitional housing or in homeless shelters or men's shelters, and really are only able to take the most, if they can even find them, the most menial of jobs and the ones that require the least skills, car wash, things like that. Any other questions? I want to talk a little bit more about the court system and focus a little bit more on child protection. We discussed the structure of the American courts 2 classes ago, and we discussed it a little bit more last class. We talked about what trial courts do, what appellate courts do, what Supreme Courts do. We talked about what the trial level court does, what grand jury does, what opening statements are, closing arguments. And we focused on the criminal and a little bit on the civil courts. There's also the juvenile courts, okay? And every state in America has a juvenile court system. They differ from state to state, sometimes significantly. But these are what they call specialized courts, and they began in the early part of the 20th century, the very, very end of the 19th century, in about 1899 in Illinois, the notion of the juvenile court system. The emphasis in the juvenile courts is on rehabilitation. The primary focus was, and still is, to a certain extent, delinquency. Although the juvenile courts do have a role in protecting kids from abuse and neglect, less so in New Jersey, but more so in other states. But even in New Jersey, there is a process called juveniles in need of supervision. And when you focus on rehabilitation and you focus on delinquency with children who commit offenses that would be crimes, you're focusing on that kid's support network. That's how you initiate rehabilitative services. You need to focus as a juvenile judge on who this kid can rely upon in order to be a success. The terminology in the juvenile courts highlights its difference from the criminal courts. In New Jersey, the primary emphasis is delinquency. And delinquency simply means an act which would be a crime if committed by an adult. So if someone commits a burglary and they're over 18, we call that a crime. If someone commits a burglary and they're 13, we call that an act of delinquency. So not only is the focus different, rehabilitation rather than punishment. By the way, the adult system of criminal law is designed primarily in New Jersey to punish. There was a time where it was focused on rehabilitation also, or rehabilitation, while not the primary reason for the criminal justice system, was extremely important. Most states have moved away from rehabilitation for adult cases and focus primarily on the punitive aspects of the adult criminal system. Some states make no bones about it. They say in their statutes, the purpose of the criminal justice system is to punish people. The juvenile system, on the other hand, its purpose is to rehabilitate kids. They're considered wayward or delinquent, in need of straightening out. Not punishment, but rehabilitation. So the language and the jargon and the words and the expressions are different in the juvenile system, and that is in part reflective of the differing posture of a juvenile delinquent and an adult criminal defendant. Nevertheless, the offenses that get you into the system, that get adjudicated in the system, and that are sentenced within the juvenile system are the same offenses and behaviors that would be crimes in the adult system. We just call them acts of delinquency. Burglaries, robberies, assaults, sexual assaults, thefts. All of those offenses and everything else in the criminal code are acts of delinquency in the juvenile system. Same elements of the crime. A burglary is entering a structure with the intent to commit a crime therein. If you enter a structure as a kid with the intent to commit a crime, you committed a burglary, but that burglary is known as an act of delinquency. You're not even sentenced in the juvenile system. Your case is disposed of. It's adjudicated. In the criminal system, you get a pre-sentence report. That is a report prepared by the probation department so that the judge understands the facts of the adult defendant's crime and the character and history of the person who committed the crime. So if you're the sentencing judge and you need to sentence Roger Redding, you don't know anything about Roger Redding. You have to make an informed decision about how long he belongs in jail. What's the best punishment? So the probation department prepares a report, and it's a mini biography of Roger Redding. It's a mini biography of him, his social relationships, his economic circumstances, how much money he makes, whether he owns property, how many kids he has, who are his parents, where are his parents, what does he do for a living, where does he work, what hobbies does he have, whether he's committed offenses in the past, does he have a criminal history. And, of course, in that pre-sentence report is a nice section on what he did in this case, what the crime is. That he broke into a factory and stole a cash box that contained $5,000, and that he was caught when his car was pulled over because someone spotted him leaving the scene of the crime. And more, they tell us the whole story of the offense. So the judge is in a position to make an informed decision about what the right sentence is. The same kind of process occurs with kids, but we don't call it a pre-sentence report. We do not call it a pre-sentence report. We call it a predisposition report. Instead of sentence, disposition. He's adjudicated, and his case is disposed of. Michael.
But what happens when a juvenile reaches the age of majority and still has prison time, or still sentenced to maybe like 21, something like that? What happens when people like that?
Well, the question was, what happens when a child is sentenced to a custodial sentence? That is, they have to go to jail or the reform school or be incarcerated in some way, and then they reach the age of majority. Well, the juvenile system has a section for kids that are beyond 18 for the very kinds of fact scenarios that you suggest, where maybe they committed their offense, their delinquency at 16 or 17. By the time their case is fully adjudicated, they're 17 and a half. There's a section for older adults within the juvenile system. There's the Youth Correctional Institute, which handles 18 to 23. And then the State Home for Boys at Jamesburg. I think even within there, they have a section that can handle kids who, to borrow a phrase from the division, age out. They turn 18 during the course of their incarceration.